Hi, everybody. My name is Karen Booth, and I'm a partner at Thompson Hine in the Washington, D.C. office, and I'm the group leader of the transportation practice. Joining me today are my colleagues Jeff Marino and Jason Tutrone, also partners in the transportation group. Thank you for joining us for today's webinar on the Surface Transportation Board's revised regulations for expedited relief for rail service emergencies. Before we begin, I need to address a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. This presentation is intended for general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, or Thompson Hine. The content should not be taken as advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, please use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can at the end of the webinar. If we don't get to your questions, we'll follow up after the program by email or phone. In the handout panel, you can download a copy of the PowerPoint slides, as well as bios of today's speakers and the program agenda. If you're having any trouble hearing, please use the dial-in number provided to you in the GoToWebinar reminder message. Thank you again for joining us, and now we will get started with the program. So the topics we're going to cover today are as follows, and we're gonna divide this up between myself and Jeff and Jason. I'm going to cover the STB's authority to issue emergency service orders and the reasons why the board has revised its existing rules or prior rules. And then Jeff is going to cover the overview of the new rules and revisions to the existing process. Jason will then address a new accelerated process and how these rules may apply to contract and exempt traffic, and then we'll plan to address your questions. So first, turning to the board's authority to issue emergency service orders, this authority comes from Congress, and what you see here on the slide comes directly from the statute. And the board has the authority to issue emergency service orders in the following circumstances. If there's a shortage of equipment, or congestion of traffic, or some other cessation of service or failure of traffic movements, and then here's the key, that creates an emergency situation of such magnitude that it has a substantial adverse effect on shippers or on rail service in a region of the US. Or alternatively, if the board finds that a rail carrier providing transportation can't transport the traffic offered in a manner that properly serves the public. So just a few key points to emphasize here. I'm sure many of you on the line have experienced these problems, shortages of equipment, congestion, failures of service. But the question is, have those problems risen to an emergency? An emergency is not defined in the statute, nor is it defined in the board's rules. So that's going to be determined on a case-by-case basis, and it's going to depend on the facts. In addition to looking at the problems, the board is going to look at what's the impacts of the emergency on individual shippers and on rail service in a region and on the public interest. And it's going to address and issue an emergency service order if it finds that there's a need for immediate relief. So if the board makes that determination, what options does it have? What actions can it take? And again, what you're seeing here on this slide comes from the statute, and it's what Congress determined could be appropriate actions. First, the board could direct the handling or routing and movement of the traffic of the incumbent carrier and its distribution over its own network or over alternative rail lines. So here you're thinking and talking about a directive order to the incumbent railroad. The board could also require joint or common use of railroad facilities, which of course would potentially bring in alternative service from a second railroad. Third, the board could prescribe temporary through routes, which could change the actual routing of the service, and again, could bring in an interchange carrier or two. And then fourth, the board could direct a preference and priority in how transportation is provided. It could order embargoes or otherwise address the movement of traffic under permits. So I think what's very important to see here is the board has very broad authority to address rail operations. What we're not talking about here is money damages for service problems, but rather the service itself. And the statute also provides that the board, when it issues an emergency service order, that order is going to be limited to 30 days of relief, but that relief can be extended upon good showing for an additional 240 days. Now, why did the board determine that it needed to revise its emergency service rules? Notably, the board first established these rules back in 1998. It had a rulemaking at that time, and it had existing rules published in the CFR. However, despite occurrences of serious rail service challenges in recent times, these rules were never used. And if we think about when the railroads implemented PSR, for example, probably around 2015 through 2018, there were very serious service meltdowns that occurred, and the board held hearings at that time to address those. But no one used these rules. And of course, more recently, during the pandemic, we've had substantial supply chain disruptions affecting all modes, including rail. But again, no shipper filed petitions using these rules. So the board had solicited input from the industry as to how it could improve these rules. And we're going to get to that in just a minute. But what it concluded as to why it needed to make changes was that the prior rules had a focus primarily on alternative railroad service as the remedy, as opposed to directed service orders. And what the shipper was required to do was it needed to not only identify a second railroad who could provide service to address the emergency, it needed to obtain a commitment in advance from that second railroad, which obviously was a major hurdle. Additionally, while the board's procedures allowed for more expedited proceedings that would otherwise be typical for an STB proceeding, they were still too long to address true emergencies. And then finally, the shipper had other burdens to demonstrate that the alternative railroad operation would be safe and not impair service to other shippers. But the shipper doesn't really possess that information. That information is more in control of the railroad, which created another problem. So with that, I'm going to turn this over to Jeff, who's now going to address the revised rules, and we'll take it from there.
Thank you, Karen. The revised rules modify what has been on the STB's rule books in 5 different ways. First of all, they modify the procedures involved. And as Karen had mentioned, the process itself was too long for many shippers to really take advantage of in what would be a true emergency situation. There was also some doubt as to whether the STB could act on its own initiative or only in response to a petition filed under these rules. In this new rulemaking, the STB has clarified that in addition to the process established by these new rules, it is possible that the board could act on its own initiative in response to shipper complaints, such as if shippers bring a procedure through the OPAGAC, the Office of Public Assistance and Government Assistance that the board has. If there's a true emergency, the board could decide to take action on its own. Third, the board modified the information that the shipper must present in its petition. As Karen mentioned, the shippers were required under the former rules to present information that typically was not within their knowledge or control. And the modifications made in these new rules now assign the responsibility or the burden to present evidence upon the party that is in the best position to possess and present that evidence. Fourth, the STB has shortened the timelines for the existing process. Now here I want to clarify, the board has long had an existing process under the rules, and these rules do shorten that timeline. But even that short timeline is often too long for true emergency processes. So therefore, the board ultimately also added a new and accelerated process for what are considered acute service emergencies. I'm going to talk about the modifications to the existing process, and then after that, Jason will address the new accelerated process for acute emergencies. The revisions to the existing process have four components: remedies, the standard for obtaining relief, the process itself, and the duration of the actual relief. What is clear now, which was not clear in the previous rules, is that there are two forms of remedies. You could get service from an alternative railroad, which was also available under the former rules. But now the board has also clarified that these rules can be used to obtain directed action by the incumbent railroad. So for example, there may be many situations where simply getting another railroad into your plant is simply not going to be practical or feasible. But you may need, for example, a car that is stuck in a yard somewhere to prevent a shutdown of your plant. In this situation, you could petition the board to order the incumbent railroad to prioritize that car and get it to your plant as quickly as possible. I want to stress, however, that this process is not about obtaining damages for any service failures. Damages continue to be governed by either tariffs for common carrier movements or your contracts for if you're moving pursuant to a contract with the railroad. Also, the board has made it very clear that these types of remedies are not to be used for minor disruptions. They truly have to be an emergency that you are facing, in which you really have no other options and your potential damages or harm is significant, or the harm also to the public interest would be significant. The standard that you must satisfy in order to obtain relief is that over an identified period of time, there has been a substantial, measurable deterioration or other service inadequacies. Now, one concern that was raised under the prior rules was whether a shipper had to prove it was captive to the incumbent railroad, or in legal terms, market dominant, meaning that you had no other economically viable alternative mode of transportation. The board clarified in these rules that there is no market dominant requirement, but it does expect that shippers with no modal options will pursue those options first, that a shipper is unlikely to petition the board if it truly has the option to ship by truck, for example. Now, the process in terms of the steps required is under this new revised process is essentially the same as under the existing process, but faster. As the shipper, when you file your petition, the railroad then has 3 business days to reply. This, under the old rules, it was 5 business days. So we've now shortened that part of the process by 2 days. The shipper then has an opportunity to file a rebuttal within 2 business days. Under the old version of this rule, it was 3 business days. And the STB has stated it will endeavor to issue a decision within 5 business days. So cumulatively, this is effectively a 12-day minimum process under this standard. This is approximately 5 days shorter than under the old version of this rule. If you succeed in persuading the STB that you have an emergency situation and that you are entitled to some sort of emergency relief, that relief will extend for a minimum of 30 days automatically. And the STB has also stated that it will presume that the relief continues for an additional 240 days unless the incumbent railroad successfully files a petition to terminate the emergency service order with the STB by showing that it can now provide adequate service. The burden of proof to terminate will be upon the railroad. Therefore, essentially, you are guaranteed a minimum 30 days, and automatically that will extend by 240 days unless and until the incumbent railroad demonstrates otherwise. Now, let's say that you decide that you do have an emergency service situation and you want to file a petition with the STB. What is it that you have to show in your petition? Well, one of the things the STB emphasized here was that flexibility is critical to this process in determining whether an emergency exists that requires STB action. Therefore, the STB deliberately avoided being very specific as to the evidentiary requirements and instead presented more general requirements and said the exact degree of evidence needed to obtain an emergency service order will depend on the facts of each individual situation. But as a general standard, the shipper's burden of proof is to establish with a full explanation and supporting evidence of a serious deterioration or other inadequacy of service. So essentially, you have to demonstrate that you haven't been getting good service, but not just good service, but that you've not been getting good service, and it is resulting in an emergency situation. You also are required to summarize any attempts that you have made to resolve problems with the incumbent railroad before filing this petition, and to explain why those problems are unlikely to be resolved within a reasonable time. This does require you, if at all possible, to attempt to make some sort of resolution with the incumbent railroad, and the STB wants to see that that has occurred in your initial petition. Now, if and only if you are actually requesting service from an alternate railroad over the incumbent railroad's lines, you will also need to identify at least one other railroad that could meet your transportation needs. Now, here is a major change from the previous version of this rule. Originally, you had to have an alternate railroad's commitment to actually provide the service. The STB listened to shippers who said it's unrealistic to require the shipper to get a commitment from an alternate railroad because an alternate railroad or another Class 1 railroad is highly unlikely to actually make such a commitment because it doesn't have a business interest in making such a commitment for a short term. And it may also be concerned about someone invoking an emergency service order against the alternative railroad in another situation. So basically, each railroad would be looking out for the others, and that was a major reason why the previous rules had not been used by shippers. Keep in mind that you also have the right to request specific service from the incumbent, some sort of directed service that doesn't require an alternative railroad. And if that's the remedy you're requesting, then you should explain what that remedy is. So that leads to the final piece of your petition, which is a detailed explanation of the specific remedy that you're asking the board to impose in the service order. Now, once you file your petition, the railroad has an opportunity to reply within 3 business days. The railroad's response must address as appropriate any of the evidence that is in the shipper's petition. The railroad also has an opportunity at this point to argue that the remedy you're requesting is unsafe, infeasible, or substantially impairs the incumbent's ability to serve other shippers pursuant to its common carrier obligation. This is another big change from the old version of this rule, because under the old version, it was the shipper's burden to demonstrate that the requested remedy was safe, feasible, and did not substantially impair service to other shippers. Well, it doesn't take much common sense to figure out how are you going to know whether the operation is safe, feasible, or impairs service to other shippers. That's information that's going to be within the knowledge of the incumbent railroad, and therefore it should be the incumbent railroad's burden to demonstrate safety, feasibility, and impairment. Therefore, the railroad presents that evidence in its reply. It's also important to note that the STB said baldly asserting safety, feasibility, or impairment claims is not going to suffice for the railroad. They actually have to present supporting evidence of those facts. Furthermore, there were some concerns expressed by shippers under the old rules that substantial impairment would mean any impairment to service to another shipper. Well, as all of you who have had any experience over the last couple of years with the railroads, when there is congestion on a rail system, if you take from one part of the system, from one shipper, and give it to another shipper, it's like squeezing a balloon. The problem will pop out somewhere else. So the STB made clear that substantial impairment does not mean no impairment. The relief you're requesting could essentially affect other shippers, but if you're in an emergency situation and the other shipper is not in an emergency situation, then you can still obtain the emergency service order and the prioritization that comes with that emergency service order, even if it has an impact on another shipper. After the railroad files its reply, you as the shipper then have the opportunity to file a rebuttal, and that rebuttal entails submitting whatever evidence is appropriate in response to the railroad's reply evidence. Now, what I have just summarized are the revisions to the existing process that had been in place for over a decade, and these were attempts to make that process more accessible to shippers. But the STB also recognized that even that process, as accelerated as it has become, may still be insufficient or too lengthy in some situations. Therefore, the STB created a new and accelerated process that shippers can use in certain situations. And I will now turn it over to Jason to address those circumstances.
All right, thanks, Jeff. So as Jeff was just saying, there's a new, I'll call it a fast track process for urgent emergencies. Now, the standard is the same as under the normal process, which is that you have to show a substantial, measurable deterioration or other demonstrated service issue or failure that requires immediate relief. But to qualify for this fast track process, you also have to have a truly urgent emergency that requires this ESO on an expedited time frame. And that emergency must be one that presents an potential imminent significant harm and threatens potentially severe adverse consequences to either the petitioner, to the petitioner's customers, or to the public. And these types of situations would include things such as a clear and present threat to public health, safety, food security, or national defense, or a high probability of business closures or immediate plant shutdowns. So, take a situation where you have a rail car. It is a critical input to one of your plants, and there's no sign that it's going to get delivered anytime soon. That would start putting you into the category of potentially an immediate plant shutdown, which might qualify you for this process. Now, you also have to have such an urgent issue that the potential harm that you're going to experience would occur before the board would be able to issue an ESO under the normal process. So again, that normal process could take up to 12 days. So if you're going to experience a harm, say within 3 days, that normal process just isn't going to be feasible or really work in this situation. So that would be a scenario where this new fast track accelerated process would likely be appropriate. Now, this process doesn't require you to show irreparable harm. So harm that goes beyond monetary harm, such as you're going to lose customers or whatnot. So it could be something where yes, there will be a monetary loss, a significant monetary loss. That would still enable you to establish that the accelerated process is appropriate for your situation. So this process, as I said, is going to be shorter than that process that Jeff was describing, the normal process. And here it's going to take about 5 days versus 12. And it starts off with the shipper filing a petition, but instead of going right toward a written reply filed by the railroad and the incumbent railroad and the potential alternative railroad, if that's applicable in your situation, there's going to be a telephone conference between all the parties and the boards and the STB staff within about 24 to 48 hours. Then the incumbent railroad and alternative railroad would have 24 additional hours to file essentially a reply to that with their service proposal, and then you'll get an STB decision targeted for within 3 business days after the teleconference. Now, under the regular process, as Jeff was saying, you get an order that would extend for 30 days, and then there would be a presumption that the service emergency continues to exist for another 240 days on top of that. Here, because we have a very streamlined process, the board is limiting the duration of the service orders to 20 days. Now, if you need a longer order, then you're going to have to go through that non-accelerated process. But that 20 days should buy you enough time so that you can go through the non-accelerated process, the regular process, and get an extended order. So what do you need to put in your petition? And here it's a little bit different than for the normal process, in part because it's streamlined. So, first thing is you need to identify the commodities and the volumes that are involved. You're also going to have to explain, the timing the timeline that you need to get this emergency service, and why that regular process is just going to be ineffective. Again, why waiting 12 days is not really possible in this scenario. The third item is that you have to give a particularized explanation of how the service deterioration or inadequacy presents an immediate significant harm and threatens potential severe adverse consequences. A fourth item that you need to put in there is you have to describe the action that you want the incumbent carrier or alternative carrier to take that would relieve this harm or adverse consequences that you're likely to experience. Another element, a fifth element, is that you must summarize your attempts to resolve the issues with the carrier. Similar to the scenario with the regular process, what the board wants you to do before you approach the board is try to address your issue through informal means. And so this requirement to summarize is really there to encourage shippers to try to reach out to the railroads and get some sort of resolution before going to the board. And then finally, you have to provide that contact information for the incumbent. Again, similar to the regular process, where if an incumbent is, well, similar to the regular process insofar as you're identifying, who the incumbent is, and also, you may have to identify who the alternative carrier is as well. Because this is an expedited process, it's limited to 5. Your petition is limited to just 5 pages, and that again, just to keep things moving quickly. Once you file that petition, then you have that telephone conference we were talking about. The participants are going to be you, the shipper, the incumbent carrier, and the alternative railroad, if there is one that in this situation that at issue, the STB staff, and then the STB can have others attend as well. During that conference, the incumbent or alternative needs to address whether the remedy that you're proposing is unsafe, infeasible, or will unreasonably impair their ability to serve other customers. Again, this is sort of that similar to on the regular side as well. This is that one exception for railroads to potentially avoid an ESO, which is to show that that the relief would lead to a safety issue, or would impair the ability to serve other customers. But keep in mind, it's got to be more than just any old impairment. I mean, it's supposed to be something significant. Now, within 24 hours, as I was saying before, the STB can either require, or railroad, if the STB doesn't require, can submit an alternative service plan, and that could be in written form or via another phone call. And just to keep in mind that the conferences will be recorded, they will be transcribed, but if you do have any sort of confidential business information that needs to be exchanged, the conference will be limited accordingly, so that it's kept confidential. Now that's the accelerated process. There's another issue around the ESO process generally in these rules, which is how does it apply to contract and exempt traffic? And this issue arises because there's a general, I'll call it a general rule, 2 general rules, which one is that contract traffic is effectively exempt from STB regulation. And then similarly, exempt traffic, of course, by its name, would also be exempt from STB regulation. And so, of course, that leads you to think, okay, well, how would this work if I have traffic that's moving under contract, or my traffic is exempt traffic? So, it could be travel on flat car traffic. There's a variety of different types of exempt traffic, boxcar traffic. How could I get an emergency service order for my traffic? And there's a little bit of a disagreement. Railroads would say that traffic that would move under a contract is outside the STB's jurisdiction, even though the emergency service order might not necessarily fall under the contract. At least that movement might not fall under the contract. They would also say that exempt traffic is also outside the board's jurisdiction. Shippers, however, have commented to the board that transportation under an emergency service order is really not under a contract. And there's, at least one case where back in the UPSP, or arising from the UPSP merger, where the board did order, did issue an emergency service order, and it did apply to traffic that had moved under a contract. Now, the board's position related to these issues is that its position is essentially what it always has been, which is not necessarily clear from looking through the precedent, but essentially it takes the position that it's not going to really decide this in advance, in part because there may be an emergency situation where it needs the flexibility to determine whether contract traffic should be allowed to move under an ESO or not. So the board's concern, again, is that it doesn't want to really decide this issue with a bright line rule in a way that would limit its capability to issue an ESO in the future. Now, it did also say that it can revoke an exemption when appropriate, and shippers can seek a partial exemption or partial to revocation of an exemption with their petition. So if you are, so now this relates to exempt traffic versus contract traffic. If you are exempt traffic, you do have, the STB does have that authority to revoke the exemption. You can seek a partial revocation, and that would be one avenue to avoid that notion that your traffic is exempt and might fall outside the ESO. So that takes us to the end of our presentation. We have some at least one question that has come in. It relates to current issue in the news, unfortunate issue, which is the Baltimore. It's a hypothetical based on the Baltimore Francis Scott Key bridge collapse, and the question is, hypothetically, if rail service into Baltimore is disrupted, what options do shippers have based on the revisions to the existing rules? And I would say, first off, the board is going to look at this holistically. It's going to look at all the facts, and it's likely going to take into account that potentially there may be a rail service disruption. It's not that arises beyond the control of the carrier. And it's going to look at likely, how is the carrier trying to meet the needs of all the different rail customers involved. And so in a situation like this, you may have many different rail customers involved. And as you may recall, we were talking about how railroads can make a point that if the ESO would adversely affect service to other customers, that might be a reason why the board should issue the ESO. And so I think that's where the board's analysis is going to go. Is it's going to look at a particular customer who may have an issue, and then it's going to look at, okay, if we direct service in this situation, how is that going to impact all the other customers who are likely impacted by this potential event? And then once it goes through that decision-making process, it'll then determine, whether we have, maybe it might be a narrow requirement that one customer gets some sort of some service. Maybe it'll be something more extended. But again, it's likely going to look at that particular customer in relation to the others to see if relief is appropriate. I don't know, Jeff, Karen, do you have anything to add to that?
No, I think, Jason, you covered it very well. I think the critical key issue at the start, would be, again, the shipper needing to demonstrate that it's an emergency situation, and back to, the impacts to its own business and potentially impacts in the region, to the point, as you made, that, this problem affects more than one shipper, obviously. So that's going to remain to be seen. But this is certainly another alternative that exists now in the STB's toolbox to address service problems. So anybody else, if you do have questions, you are welcome to submit them in the question box. At this point, that was the only question, right? Yeah, while we have just a few more minutes, the only thing I guess I would add to the comments we've made is, we often get the question, well, what constitutes an emergency? And as I said earlier, it is fact specific, case by case. But just, to give you an example, one recent example that, again, wasn't brought under these rules because the rules weren't working well. We did have in 2022, so it's very recent, the Foster Poultry Farms case where the shipper, Foster Farms, did petition the STB for an emergency service order, but they petitioned under the statute. So what I had outlined earlier, and not the rules, because the rules had all these other problems and hurdles. But there, the emergency was the lack of UP providing sufficient unit trains of corn that were moving from the Midwest to California. And that feed was needed for tens of millions of chickens and also to provide corn for cattle. So the lack of service in that situation was a true emergency. There was risk of, the chickens starving, which, the board agreed was a true emergency. And they did do an ESO, and they did it within 2 days. That's one example. And of course, the board, I think, would hope and expect that now that these rules have passed, that shippers would use the new rules in that process, because there were other examples of a coal shipper who also used the statute, and that I think took several months, and they didn't get an ESO, they got an injunction. So it was very, very, I think, complicated based on the particular situation. So now with these new rules, I think this is the process that the board is really going to be hoping and encouraging shippers to use, again, to address operational service remedies, not damages that are acute. Anybody else have any comments?
I would just say on the Foster Poultry decision, that's probably an example of where that accelerated process that I was talking about would likely be applicable. You've got an issue that is truly a significant emergency. So, just keep that in mind when trying to think about, okay, does my issue rise to the level where I get into that accelerated process? That's probably one where I would say yes.
Great. Well, if there's no other questions, we really want to thank you again for attending today's webinar. As noted at the start, the program was recorded, and we will send a link to all attendees within 48 hours. If you do have additional questions, please don't hesitate to reach out to any one of the speakers at any time. We invite you to go to our website and register to receive our mailings for transportation updates if you don't already receive them. And thank you all for your interest in attending today's webinar. We hopefully you will enjoy the rest of your day, and please be well. Thank you.